Okay, we can go ahead and get started. Thank you, everyone, for coming to this session for our summer legal or civil legal education series. The session is on paternity law in Indiana and why it matters in domestic violence cases. Our presenter today is Kerry Hyatt Bennett. She is the Chief Legal Counsel for the Indiana Coalition Against Domestic Violence. And she's here today to tell us a little bit more about paternity law in Indiana. So I'm going to mute myself and let her go ahead and get started.
Okay, thanks, Aubrey. If there is anything in the chat or something, will you just interrupt me, please? Because it's difficult to be able to track all of that sometimes when you're presenting.
Absolutely. I'll monitor the chat today.
Bless your heart. Thanks. Good evening. Good evening. My name is Kerry Hyatt Bennett, as Aubrey said. I'm the Chief Legal Counsel at the Indiana Coalition Against Domestic Violence. And what that means is I am the general counsel over the organization that oversees all of the domestic violence programs in the state of Indiana. So we have between 80 and 100 domestic violence affiliated programs. Some of them are shelters. Some of them are non-residential facilities. Some of them are batters intervention programs, which are now called abuse intervention programs. We have domestic violence prosecutors as members too. We work a lot with judges. We do a lot of training. We're sort of the domestic violence subject matter expertise people in the state of Indiana. We provide expert witness testimony, usually for free, in both civil and criminal cases. And our focus is on intimate partner violence, sexual assault, and stalking response and prevention. So I serve as their general counsel, which means from a legal perspective, we do a couple of different things. We provide direct legal services to survivors in their emergency hearings, like an emergency protection order hearing or an emergency eviction that might be related to a domestic violence case. We expunge evictions if those existing evictions were dismissed and the record of that eviction keeps someone from getting affordable and viable residency somewhere. We just try to use our legal powers for working with survivors of domestic violence to try to take away those barriers. It's one thing to leave an abusive relationship. It's another thing entirely to stay out of an abusive relationship. And we find that that largely depends on access to things like housing, access to competent, well-informed legal assistance that they can afford or that is working pro bono. So we contract with about 50 attorneys all over the state of Indiana, and we pay those attorneys to represent survivors in their emergency domestic violence related hearings. So if you're interested in that aspect of what we do, please reach out to me, because we pay a modest means hourly of $75 an hour to attorneys. Certainly always need attorneys, especially in legal deserts that have been identified by the courts. And it's been an exceptional program. I have a lot of people have really based their practice on this work. So it's been overwhelmingly successful. It's a win-win-win. It's a win for the survivor, because it's usually the survivor that can't afford to hire an attorney on their own. Part of the manipulation and control tactic is the fact that they're being threatened with litigation and they can't respond appropriately. So if we can provide them with an attorney that understands what domestic violence survivors are going through and some of those systemic barriers that they have, then it's a huge win for the survivor. It's a win for the practitioner, because it's income generating, they're making money. And the courts like it, because the courts prefer when people that are marginalized or don't have a voice have a voice. And we find these cases go much more smoothly when we can provide that particular survivor with counsel. So I'm going to do this long pause and breathe thing just in case Aubrey needs to interrupt me. So every once in a while, don't hesitate, okay? So today we're going to talk about kind of an under-considered issue, when it comes to domestic violence. And if you know that domestic violence is all about power and control, and it really is about power and control. It's not about damages. It's not about injuries. It's not about that. It's about power and control. It's about considering the intent of the action and what it is designed to do. So we know that 320,000 pregnant women are abused in this country per year. What's interesting to me, I also teach at IU McKinney School of Law. And what's interesting to me is when I tell them that your chances of becoming abused actually increase when you're pregnant, people are almost always surprised by that. But if you understand what domestic violence or intimate partner violence is, it makes complete sense because it is about power and control. So your rate of being abused actually goes up when you're pregnant because that's taking control away from the abusive partner. So 320,000 pregnant women are abused in this country per year. Statistics also say nearly half of all domestic violence survivors report that their abusers limit their childbearing decisions. Because if you lose your ability to control your reproductive health, then that is an excellent way to control you. I cannot tell you how many clients I have had that have not been able to get out of relationships because of children that they were forced to have. It's a very real issue. So one of the things that we are concerned about is reproductive freedom, because reproductive freedom adds to the individual autonomy of that person. If you can control your own reproductive cycle, you can control your own autonomy. If you cannot control your reproductive cycle, you cannot control your autonomy because then you're automatically dependent on the system or someone else. So we also know that homicide is the second leading cause of traumatic death for pregnant women in the United States. Again, your rates of abuse go up when someone gets pregnant. Very often I've had clients who have never been physically abused until they were pregnant. And when they were pregnant, their being pregnant exacerbated the abuse, which went from a hyper-controlling situation into physical abuse. Let's talk a little bit about the power and control around domestic violence. Domestic violence is keeping somebody from having their own money, keeping somebody in the house and taking away their transportation in rural areas, not allowing them to work, keeping them pregnant all the time, insisting that they stay home and not giving them freedom to go see their family or their friends or their colleagues. There's lots of different kinds of abuse, certainly illegally. Is physical violence, but domestic abuse stems from power and control issues, and the precursor to that physical violence is usually control in other ways. So who are our victims? 85% of reported domestic assaults, the female is the victim and the male is the perpetrator. 1 in 4 women and 1 in 7 men will experience severe physical violence by an intimate partner in their lifetime. 1 in 3 women and 1 in 71 men will be raped at some point in their lives. People with disabilities are sexually assaulted at a 3 times the rate of people without disabilities. And most incidents of domestic violence and sexual assaults are not reported to the police. I know this is a really small group, so if there's any questions, anybody wants to add anything on, let me know when there's a hand raised, because I would really appreciate a dialogue instead of me just lecturing to you. This is everything that we know about this kind of work, and it's critically important, especially now. Indiana is 2 times higher than the national average for child abuse. And Indiana ranks 3rd in the nation for child fatality rates. So with everything that we know, if we know that intimate partner violence is about power and control of another person, and we know that abuse often starts or is exacerbated during pregnancy, and pregnancy almost certainly makes it worse. Our clients are less safe when they're pregnant, And children born in this situation often become tools of control or tools of access. Here's our question. How can we best educate and empower pregnant women survivors about their rights and their control before the baby is born? Hence the segue into Indiana paternity law and what it means when you have a child born out of wedlock, who has what rights, what survivors need to know, because what they do when they have that baby cannot be undone legally unless somebody lawyers up and goes to court. So it's important that survivors understand that the paperwork that they go through when they have a child born out of wedlock is critical to their future ability to have access of that child, control over that child, or keep that child from the offending parent. Does that make sense? Okay, so now we're going to segue into Indiana law and what that means. You know, what's interesting to me is if you go to any hospital in rural Indiana where a child is born out of wedlock, you now know, or you will know at the end of this, is that they have a statutory duty to legally advise these young women of the rights and responsibilities of executing a paternity affidavit. And what I want to know is who's doing that? You know, who's doing that in these small rural hospitals when somebody's given a bunch of paperwork to fill out after they have a baby? Yes, Jean.
Can you say again what you said? They have a statutory duty of what was the rest of that?
I'll show it to you. They have a statutory duty, according to this paternity statute, they have a statutory duty to not only give them the forms to execute, but to do it in very specific ways. Like if I was at the hospital and this was my job, I have to give it to the person that had the baby out of wedlock. I have to explain their legal rights and responsibilities. And to my knowledge, they don't have lawyers doing that, you know? I have to make sure that the person has a chance to consult with the adult of their choice. And all of this is in the statute, Jean, and I'll send that to you.
Okay.
You know, and I have to make sure that they understand everything on this legal form, because whatever they're executing now is not going to be able to be undone until somebody goes to court and chooses to try to challenge it. Nobody knows this. This is why, to me, this is such an, I mean, I've done this training for nurses, for OBGYNs. I've done it for hospitals. I've done it for, and I have a DV interest in this because that's my area. But I'm just talking about in general, when children are born out of wedlock, nobody knows this part of the law. So that's why I think it's a decent thing to talk about in these trainings, because I think it's interesting to know, frankly. But so let's talk about the Indiana law. So Indiana law, paternity, children born out of wedlock. First of all, the most important thing to know is that when you have a child that's born out of wedlock in the state of Indiana, mom has sole physical custody of the child. That's per this statute 3114-13-1. Mom has sole physical custody of the child. Now, depending on the paternity affidavit that is executed, if the father is there at the hospital at the time the child is born, they may or may not share joint legal custody, but they probably don't. And I'm going to explain to you how this convoluted statute works. It's amazing, obviously written by lawyers. So mom has sole legal or sole physical custody of a child born out of wedlock, and probably legal as well, but it depends on the paternity affidavit. You know how many people are, you know, how people say, well, he's on the birth certificate. He's on the birth certificate. Oh yeah, I will share my slides, the forms, all of this stuff. He's on the birth certificate. Well, the birth certificate is more or less like a tchotchke. It's an important legal document, but it's the paternity affidavit that really outlines the rights and responsibilities of the parents that are present. So mom has sole legal physical custody. Paternity affidavits is under a different part of the Indiana code, and that's 1637-2. And 1637-2 says that when paternity affidavits are executed in the hospital, I'm going to show you a copy of one of those now. I'm going to stop sharing and then pull up a couple of things and then share again. So I'm going to send you both statutes, Title 16 that paternity affidavits are under, and also 31 that talks about sole legal and physical custody. I'm going to move this over to here, and then I'm going to share my screen again. So now we're going to look at the paternity affidavit. This is the paternity affidavit that is executed in the hospital. You see that? Okay. So it's a standard form. Everybody has it. And I'm going to give you a copy of this when I send out the handouts to Aubrey. But what's interesting about this, and pursuant to the paternity affidavit statute, is the hospital personnel must provide the opportunity to the child's mother and, quote, a man who reasonably appears to be the child's biological father. That's how it's defined by statute. So this is a critical part of this paternity affidavit. This talks about the acknowledgement of paternity, and what this establishes this person as the legal father of the child for the purposes of later on establishing a child support order. You don't have to have a DNA test. You don't have to have a swab. You don't have to do any of that stuff like you used to have to do. If you execute the first part of the paternity affidavit, you're both agreeing that he's the legal father of the child. So you don't have to do all that stuff down the road, right? So that's the whole purpose of this. So the first part of this is pretty straightforward. It talks about the acknowledgement of paternity. It talks about the biological father's information and the biological mother's information. It talks about the child's name on the Indiana birth certificate. How do you want the name? Do you want the father's last name? Do you want the mother's last name? All of this has to be agreed upon. Okay. And this is where it gets tricky. And this is where I question what's going on, because what I want to know is who in these little Indiana hospitals or even home births, who's giving this form to these people. And from a survivor's perspective, because I know that when a domestic violence victim is pregnant, their incidence of abuse go up. I worry that survivors are being pressured into executing paternity affidavits for lots of reasons. Shame, shame of not saying who the father is, fear for their safety, threats, etc. So, but what's so important about this is all of this legal language here has to be read and explained to the person that has had the child and also the father, but it has to be by statute, it has to be explained to them separately. So they both have the ability to be informed, but in separate areas. And I don't even know if that's being done, but that's what the statute says. And what's interesting about this is we know that if they both sign it and fill out the first part, then we've established him as the legal father of the child. But it goes on to create section F here that says, if you both agree, and if you understand all of these legal rights and responsibilities, and they give you a link, like you're supposed to click on it and pull up something when you're in a hospital somewhere. And if you agree to all of this, then you can also share joint legal custody. See these little boxes here? If both of them understand it and they both check the box and sign, then they both have joint legal custody of the child. And that's when, from a survivor's perspective, that's when the victim loses control over that child, right? So if I'm a victim of domestic violence, and let's say I'm forced to have a child that I didn't want to have, I've worked with survivors that have, after they've left their abuser, they they basically go underground. They don't want them to know when they have the child. They don't, they're concerned about not putting someone on here because they think it's against the law. If they don't put somebody on the paternity affidavit, it's not. There's all kinds of, it doesn't mean that the father can't always take that person back to court. That's just the way it works. But you don't have to make it easier for them to continue to control you. So Section F allows them to establish joint legal custody, which you guys know means that you have equal decision-making ability over that child. So you already lose a certain amount of control over that child, which in cases of domestic and intimate partner violence is a concern for all. Okay. And to be even more convoluted, this part of the statute says, if you check that box within, I want to say 60 days, but sometimes my head says 90. I think within 60 days, you have to verify this with a follow-up DNA test. So what I find is even if I see people that check the box, they never follow up with a DNA test. So most of the time when people execute a paternity affidavit, they don't execute the joint legal custody part, and they do execute the part where somebody is the legal father. All of this is to say that all of this matters when you're working with survivors of domestic violence. And the sooner you can tell someone during their pregnancy about what these rights are going to be and what these documents are going to look like and how to familiarize yourself with them before they have a child, the better that's going to be for them, because it allows, we're all about letting somebody retain their autonomy. Let them control their own life. So this is what the paternity affidavit looks like. It's a 2-pager, but it's got a lot of legal information. This form has legal consequences. You may want to talk to an attorney before you sign it. I don't know if anyone's ever given a chance to do that. I don't know who's helping them execute this form, but I know this is a legal document that's going to be done with a bunch of other paperwork when a child is born out of wedlock in the state of Indiana. That's not going to be undone unless somebody lawyers up and goes to court. And to me, that's an area of concern. Okay. So if you sign this paternity affidavit and you establish that person as the legal father of the child, but you don't check the joint legal custody boxes, that also establishes Indiana parenting time guidelines right off the bat. So it doesn't change sole physical custody belonging to the mom, but it does say that there's Indiana parenting time guidelines. Does that make sense? Just stop sharing that part now. Did I do that right? And go back to that. Okay, so I'm going to send all of this to Aubrey and she can send this on to everybody, but the paternity affidavit statute is right here. Paternity affidavit may be executed in a hospital or a local health department. It gives parameters as to when and how. It must be executed on the form provided, which is the one I just showed you. It gives very specific parameters. This is the top part that basically establishes the person as a joint legal custody. And the second part of it is down here where it really talks about the legal rights and responsibilities, why this establishing paternity is so important. It's not going to be overturned, it isn't going to be changed unless there's a court order changing it. What's really interesting to me are some of the little nuances of this, like, did you know that in the scenario that let's say I'm pregnant with my abuser's child, but I have a male friend of mine who's my best friend, and my best friend says, why don't you just put me on the paternity affidavit? It's safer. We'll raise the baby together. It's going to be okay. So what's interesting to me is if that happens, then it's a crime for the woman, but it's not for the man. Okay, so if a woman knowingly puts somebody on the paternity affidavit that is not the biological father of the child, that's actually a misdemeanor in the state of Indiana, which kind of stuns me, but it is true according to this paternity affidavit. Really, it's sexist. Anyway, so I always think that's interesting. You can search for a paternity affidavit in the county where the child is born. So if I'm working with a survivor from LaGrange County and she says, I've had a child born out of wedlock and he's taken off with a child, what do I do? First thing I'm going to wonder is there a paternity affidavit? Because that will tell us what these custodial rights are, right? Is there a paternity affidavit? And if there is a paternity affidavit, was it signed or were the boxes checked or what's that? Either way, for someone to take off with a brand new baby that's born out of wedlock, mom still has sole physical custody under Title 31. So that's still technically a violation of custody. And these are the kinds of cases that our satellite attorney project help with. Jean, where do you practice? Are you in which county?
Wayne County.
So let's say you're one of our contract attorneys, and then one of my domestic violence shelters says, I've got a woman in Wayne County and she and her, and she has a protective order against this guy and he took off with the child, and law enforcement won't get involved because law enforcement says, well, he's on the birth certificate. Okay. Which is technically wrong because law enforcement should know that under Title 31, mom has sole physical custody. But more often than not, law enforcement will say, he's on the birth certificate, there's nothing we can do, it's a civil matter. That's when we tap into our satellite attorney network and say, hey, can you represent this person? We'll pay you to represent this person to file something to try to get that child back because she has sole physical custody of the child. So that's how this project works. It's that kind of emergency legal intervention that has been critical for survivors because they usually can't lawyer up and find someone. They don't even know what those legal rights are. So what they'll do is they'll find out what those rights are, usually from the domestic violence program. And then ideally we can find them counsel to help them. Questions?
I'd never heard of that paternity affidavit, and I work with our local homeless shelter women, and we get several up there that are pregnant, and it'll be interesting. I'll ask them, were you ever presented with one of these to fill out while you were in the hospital?
I would love to know what you, I'm legitimately curious how this works in real life, right? I know what the law says, but I'm legitimately curious how this works in real life, especially rural communities. Because I can't imagine they have anybody with a legal background that's sitting down and explaining to people,
No,
or even
I can't. They can hardly get you released legally, but something like that. So we've had 3 ladies in the last year at least that have had children out of wedlock. So I will go back and talk to them and ask them if any of them were ever presented with this form or this information. How did they get it?
Yeah.
If they didn't, it'll be interesting to see what the results are.
Yeah, well, feel free to shoot me an email and because I just think this is interesting. I think hospitals need this. I mean, I think hospitals need to understand what their legal responsibilities are. There's got to be some liability in here somewhere. And that really concerns me. Because if I don't know these rights, just because I've got somebody saying, well, you have to read this paper and then sign it, I can't imagine how many people are pressured by either the system or that person's family, whether it's their family or his family, pressured into putting somebody down as the father of the child, even though you may not think that's safe for you or the baby. I fiercely want to guard that kind of autonomy while they still have it, because signing that paper means they lose it. You're immediately losing control, because once you have a baby with an abuser, you have lost a lot of control over your autonomy. For the next 18 or 20 years, you're going to be subject to the whims of somebody that's going to be using that child as tools of control and access. And that's bad for everybody, especially bad for the child. So to kind of recap, if there's no paternity affidavit at all, mom has sole legal and physical custody of the child. And if there's a paternity affidavit and it's just signed by both parties, but the joint custody boxes are not checked, then mom has sole physical custody and sole legal custody, but dad has parenting time, has Indiana parenting time guidelines. And then if the joint legal custody box is checked and there's that follow-up DNA, which is very rare if ever, because most people may read it the first time and then they immediately forget. So if they check the box and they don't get the DNA test, then the box checking is void, so it's effectively not checked. So if they do all of that, then there's joint legal custody. But what we're finding out is that is very, very rare because most people don't have the bandwidth to remember that part right after they have a baby. You know, like there's not enough going on. So one of the things that we try to do as professionals that are trying to be trauma informed is remember the survivor's best interest when you're doing this, what they're going through, what their history is, advocate for these choices, and stress their autonomy. Stress their autonomy. The more autonomy they have over their own bodies and their child's bodies, the safer they will be from somebody that is a classic abuser. It's never going to defend somebody if they want to ultimately go back to court and establish paternity and all of that. It isn't going to keep that from happening. You just don't have to do it for them. So, questions? I was really fast. So, but I think it's a fascinating area that a lot of people don't know about. And I worry that hospitals out there are not aware of their legal responsibilities to do this the right way. We've often thought about pitching like closed circuit videos for two separate rooms, you know, the fathers and the mothers, you know, before you have this child or when you're, or after the baby's born, just something that they can watch that explains the paternity affidavit to them. Because I think that would be in everybody's best interest and it would fulfill the obligation that the hospital has.
So is the general advice to women who are pregnant and survivors of domestic violence to just completely not fill out the form and just kind of like ignore it? It's not like a required thing for them to do. Is that correct?
Depends on how safe they are. We leave it up to them, but we want them to know that it's not mandatory. You know, it isn't against the law to put I don't know. It isn't against the law to say I'm not going to put down his name because he's abusive, or because I am the victim of a sexual assault, or something like that. There's nothing wrong with that, and we just want to make sure that people feel no shame for doing that if they don't feel like they're safe, and that they do have options while they still have options. Because if they don't know they have options, they're going to lose those options. But we leave it up to them. If they think it's something that they can do safely, that's fine. We just want them to know the law.
It's almost like there's the social workers in the hospital that work on their discharge and all of that it would be their responsibility. I mean, anymore, if you have a baby, you're pretty well out of there in a day.
Right.
So it would be the social worker's responsibility to present that information to a mom.
Right.
And
I understand best case scenario is a functional family that, that everybody gets along and they just happen to not be married. That's great. But I'm not talking about those families. I'm talking about people that are in cycles of abuse, people that are having children against their will, people who have lost their own reproductive autonomy. And, I've had women that could never get out of abusive relationships because they have so many kids with them. There's just no way to get out and take the kids with you. It's just not going to happen. They make that choice. But the fewer barriers that we that we take away, or the more barriers we take away, the easier it's going to be for them, especially when they're starting out, when you're, when they're starting out and you're explaining this. So.
Very interesting.
Thank you. So thanks, Aubrey. I'm sorry that was so fast.
No, that was great. I think that was, like I've said to you in the past, I think this is such an interesting topic. And like you've said, I don't think enough people know about it. So I'm glad to have this resource.
I've done this for hospitals. I mean, I already told you this, but it's amazing. I do this for so many different people and they're like, what? And it's like, totally. I mean, I was like that before I actually sat down and read the statute. And when they changed the paternity statute to include guideline parenting time, what we did as a domestic violence organization, feminist organization, we said, well, if you're going to have guideline parenting time, you should also put like a baseline child support order, right? Because we all know it takes more than just, parenting time to parent a child. So if you're going to do Indiana parenting time guidelines, why don't you do like a minimum child support order of $30 a week or something like that? They wouldn't hear that. That was not okay. But anyway. So, but again, we just firmly believe that anything that can help survivors and women in general retain their autonomy, the better off. So
absolutely. Felicia, are there any questions from the group there?
No, I asked them, but I do have one question. Are you presenting again this year at the Civil Legal Aid Council conference?
I am. In fact, they just emailed me about that today. So my proposed, you want to hear my proposed topic?
Absolutely.
Okay, get this. Let me know what everybody thinks and if they start laughing uproariously. My proposed topic is the Supreme Court of the United States 2324 and how those decisions will impact social determinants of health.
Oh, I want to be there for that one.
So we're talking, we're going to like a deep dive into the housing cases and the Loper Bright case and the admin cases, because all of that's going to be so relevant. If the admin rules that control how many bolts put an engine on an airplane, all of that stuff's going to be really relevant to our day-to-day lives. So hopefully I can take what I just said and have it make some sort of sense by the time the Civil Legal Aid Conference comes.
I think that'll be great.
So where will you present that at?
That's going to be at the Civil Legal Aid Conference. It's really a good conference. Jean, if you have a chance, and I can send you a link too, but I'm sure everybody else has it. It's the Civil Legal Aid, and it's for a lot of legal service lawyers, but it's for lawyers in general. It's in Indy, but it's like, I really appreciate it because it's the kind of stuff that we all do every single day, and just a really, really good group of people, solid people there.
Appreciate that.
Lots of CLE. So. All right. Well, if anybody has any questions, I will send the PowerPoint, paternity affidavit, and those statutes to you. Is that okay, Aubrey?
Yes, absolutely. We'll get them sent out.
And for those of you who don't know, big shout out for Aubrey. She starts law school in the fall. Don't tell her not to go.
Very excited.
Turn around and go.
Thank you. I'm very excited. So it's because of work like this that I am driven to do it. So thank you for everything that you do and for being here to present this topic today.
You bet. Stay in touch, everybody. Thanks.
Thank you.